What if the U.S. Supreme Court rules against the Biden administration, preventing them from implementing the president's student loan forgiveness plan? What are the alternatives, if any? What happens if the Biden administration prevails? In this video, we're going to explore some of the alternative paths to student loan forgiveness if President Biden's blanket student loan forgiveness plan is blocked by the U.S. Supreme Court, including any potential challenges to these alternatives. Hey everyone, this is Andy Hill from The College Investor, investing and personal finance for millennials. If you're new to the channel and like what you hear, please hit subscribe so you're ready when our next video comes out. Thanks. Plan A, President Biden succeeds at the Supreme Court. If the Biden administration wins both cases before the U.S. Supreme Court, they will implement forgiveness quickly. The U.S. Department of Education will tell the student loan servicers to proceed immediately with forgiveness. This can take 1 to 2 weeks to complete. Processing the remaining applications plus any new applications will likely take a few weeks as well. If the cases are dismissed because the plaintiffs lack legal standing, it is possible that a new plaintiff who does have legal standing will file a lawsuit to block the president's plan. They would likely seek a temporary injunction to stop the Biden administration from forgiving student loans while the case is considered. The main plaintiff who has legal standing is Mohila, since the Biden administration acknowledged during the hearing on February 28, 2023, that Mohila would have legal standing. But Mohila is unlikely to file such a lawsuit, or it would have done so already. It is also possible that the U.S. House of Representatives could bring a lawsuit to block the president's plan. Now let's discuss some alternative paths to blanket student loan forgiveness. If the Biden administration loses either case before the U.S. Supreme Court, they will be unable to rely on the HEROES Act of 2003 to implement the president's student loan forgiveness plan. So what are the alternatives? The decision of whether to pursue another approach to loan forgiveness may depend on politics more than policy. The Biden administration may decide to let the U.S. Supreme Court decision be the end of the matter. As a result, the administration may shift their focus to other forms of financial relief for student loan borrowers. The new Repay plan does provide significant financial relief to struggling borrowers, cutting monthly loan payments in half on undergraduate student loans and providing earlier forgiveness for borrowers who started off with a low loan balance. But proponents of forgiveness may pressure the Biden administration to do something further on student loan forgiveness. There are a few options, including a permanent extension to the payment pause and interest waiver, waiver authority under the Higher Education Act of 1965, and using the regulatory authority under income contingent repayment to create a new forgiveness plan. None of these options, however, seem like a good solution to us. How about Plan B, permanent payment pause? The president could decide to extend the payment pause and interest waiver indefinitely. Not only does this provide ongoing financial relief to eligible borrowers, but the paused payments count as payments toward public service loan forgiveness and the 20 to 25 year forgiveness at the end of an income-driven repayment plan. The authority to implement the payment pause and the interest waiver is based on the HEROES Act of 2003. The authority to implement the payment pause and interest waiver ends when the national emergency ends. The president has expressed an intention to end the national emergency declaration soon. The Biden administration has said that its authority to implement the payment pause and interest waiver will continue beyond the end of the national emergency because the economic impact of the pandemic will continue. That might be sufficient for the current, which is the 8th extension, to reach its conclusion 60 days after the U.S. Supreme Court issues an opinion in the pending lawsuits, but it would be rather awkward for the Biden administration to issue a new extension. Of course, the president's plan to end the national emergency declaration could change. Perhaps the COVID-19 virus will mutate and cause the start of a zombie apocalypse. Or maybe space aliens will land on the White House lawn. There's always the potential for an excuse for an extension to the payment pause and interest waiver. There are currently 42 national emergencies in effect, but a pending lawsuit may block further extensions to the payment pause and interest waiver. SoFi filed a lawsuit on March 3rd, 2023 that seeks to end the payment pause and interest waiver. SoFi, a lender of private student loans and private refinance, argues that the latest extension is not connected to the pandemic and therefore not justified under the HEROES Act of 2003 since it does not relate to the pandemic. SoFi also argues that it is not narrowly targeted to affect individuals. The briefing schedule in the lawsuit runs through June 26, 2023, so it is unlikely to cause early termination of the current extension. If SoFi wins its case, it is likely to be a useless victory since borrowers are unlikely to refinance their federal loans with a lender who forced them into repayment. Also, by then, the interest rates on private student loans will be much higher than most federal student loans, even for borrowers with excellent credit. How about a plan C? Higher Education Waiver Authority. Well, some proponents of student loan forgiveness have claimed that the president has the authority to forgive student loans using the waiver authority in the Higher Education Act of 1965. There are several problems with this approach. It depends on a misreading of the Higher Education Act, taking the waiver authority out of context. The preamble of that section of the Higher Authority Act limits the authority to the authority vested in the U.S. Secretary of Education by the Higher Education Act. In other words, they can forgive student loans only as previously authorized by Congress. The waiver authority appears only in Parts B and E of the Higher Education Act. Part B covers the Federal Family Education Loan Program, and Part E covers the Federal Perkins Loan. Part D, which covers the William D. Ford Federal Direct Loan Program, is noticeably absent. To address this, one has to try to rely on the Parallel Terms Clause, but waiver authority is not a term and condition of the loans, but rather external to it. In particular, it is subject to the limits on waiver authority that appear in 31 CFR 902.2, which limit waivers to situations in which a borrower is unable to repay the debt and which require the federal government to collect the loans through wage garnishment and treasury offset. In addition, federal agencies are required by 31 CFR 901.1a to aggressively collect all debts. Also, to the extent that the HEA waiver authority was mentioned in one of the legal briefs, the U.S. Supreme Court may decide to address it. Then there's Plan D, forgiveness through income-driven repayment. The four income-driven repayment plans, ICR, IVR, Pay, Repay, are effectively loan forgiveness plans. They forgive the remaining debt after 20 to 25 years worth of payments. Congress provided broad regulatory authority for income contingent repayment sufficient to make ICR into a broad student loan forgiveness plan by changing the percentage of discretionary income, the definition of discretionary income, and the number of years until forgiveness. This is not just a theoretical argument, as this regulatory flexibility has already been used twice before in creating the pay and repay plans. These new repayment plans cut the percentage of discretionary income from 20% to 10%. The law doesn't allow the number of years in repayment to drop below 5, and there's some question whether it could drop below 10, but certainly they could create a means-tested forgiveness plan that forgives the remaining debt after 10 years in repayment. They could also allow payments in other income-driven repayment plans to count toward forgiveness. So borrowers who had already been in repayment could switch to the new repayment plan and have their loans forgiven. The Biden administration did include some ideas along these lines in the updated repay plan. For example, borrowers who initially owed $12,000 in federal student loans will have their loans forgiven after 10 years instead of 20 years. Each additional $1,000 yields a year until the loans are forgiven. They decided to do this instead of delaying the publication of the Notice of Proposed Rulemaking, or NPRM, until after the U.S. Supreme Court ruling. Since consensus wasn't reached during negotiated rulemaking, the U.S. Department of Education could do whatever it wants. in the NPRM. But they decided to go forward with the revised version of Repay. The public comment period on the NPRM has ended on February 10th, 2023, with 13,000 public comments. If the final rule is published by November 1st, the new version of Repay will go into effect on July 1st, 2024. In the end, what really will happen is anyone's guess. Know that we'll be tracking it along the way here on this channel. Subscribe to our channel to get updates on all things investing and personal finance for millennials. Thank you so much for hanging out today. This is Andy from The College Investor. We'll see you in the next video.